The legislature is back in session. We're back at the top of the second reading file. Senator Rodriguez on Bill 42.
Thank you, Mr. Speaker. Mr. Speaker, I move to send the bill back to committee.
Thank you very much. Any objection? Hearing none. Next on the agenda is Bill 45. Senator Snogestein, you're recognized.
Mr. Speaker, I move to
Accept.
to bring Bill number 45-34 as corrected by the prime sponsor and amended by the Committee on General Government Operations and Federal and Foreign and Regional Affairs and substituted on the floor.
Okay, the move to accept.
Mr. Speaker, before we accept, could we please just hear what is the difference between this new floor version and the one we reviewed yesterday?
Why don't you just explain what the changes are in the substituted?
Mr. Speaker, the changes are, we found that there were at least 7 or 8 pages that were duplicated and just repeated again and attached. So they had to go back and take it all out.
Okay.
That's the only changes.
All right, move to accept. Any objection? You're recognized to speak on the bill. Whatever.
Mr. Speaker, the bill is designed to reform the election process to make it easier for new candidates to run for office. This is the first step in making our government more responsive to the people. The current primary process is designed to minimize competition against the political parties. The bill will encourage more people from all walks of life to run for elective office. This bill corrects a financial wrong. As it is set up now, the purpose of the primary election is to select candidates to represent the Republican and Democratic parties. That is the function of the parties and not a function that should be paid for by taxpayers. This bill will make the legislature more democratic. Some of my colleagues expressed concerns that without the primary and allowing anyone to run the general, then that can get signatures in the ballot. The election will turn into a free-for-all. More competition will just require candidates for office to work harder to get elected, like what was brought up yesterday on the bill and signs. There has been concerns voiced about having to have runoff election. I have provided all my colleagues a copy of the Supreme Court Justice that the Organic Act, number one, the Organic Act only requires a majority of votes to run for office of governor and Washington delegate. A majority has 3 definitions. 1, the largest number, 2, 50% plus 1, and 3, a specified number such as 2/3 or 80%. There exists no law mandating the use of 50% plus 1. Therefore, we should use the traditional use of majority, the largest number, which will minimize the risk of a runoff. Remember that the U.S. Supreme Court, which I provided you all a copy, validated the use of the largest number of votes received when Governor Carl Gutierrez was elected governor with 49.25% of votes cast. And the Supreme Court of the United States confirmed that election. In a 3-way, 4-way, or 5-way contest for governor or Washington delegates, candidates will be forced to work harder to get the largest number of votes cast to get elected. We won't have to have a runoff unless there is a tie at the top of the vote count. Another concern is that some have voiced that how will we determine who has a majority if we allow independent candidates or non-party sponsored candidates to get elected? To that concern, I submit that the first act of the legislature will be to negotiate alliance and elect their officers, as is done in every other democracy that has multi-party legislative bodies. I urge my colleagues to pass this law, or to support this law, and to make the election process easier for more people to participate in the governing process.
Thank you, Senator. On the main motion, any senator wish to be heard? Any Senator Nicholas?
Thank you, Mr. Speaker. Mr. Speaker, there's been some assertions that I think are are inaccurate with respect to how this bill would impact the outcome of elections. One of the assertions is that in the general, you don't need the 50% plus one, but I don't think that that was actually what the justices said in the case Gutierrez versus Ada. And I'll go ahead and read what was actually provided by the author. It's on the second page, and it says, in a unanimous opinion delivered by Justice Souter, the court held that, quote, the Guam Organic Act does not require a runoff election when a candidate slate has received a majority of the votes cast for governor and lieutenant governor of the territory, but not a majority of the number of ballots cast in the simultaneous general election, end quote. Very clearly in that statement, they're saying if you get a majority of the votes, you don't need a runoff. Even if the number of ballots, when counted, does not add up to that majority. And I remember this was like one of the cases where, you reach that age where you actually start really paying attention. And I was a really young man then, and I was kind of livid about how they were even trying to count ballots. So I vividly remember that the ruling of the court was that if you get a majority of the votes, you don't need a runoff. So if we have only a general election and none of the candidates get a majority of the votes cast for governor, then we may have an issue there. So, that's one of the things that we need to consider. And another thing, too, that I was worried about was, like, let's say, for example, the mayoral races. Oftentimes, we'll see villages that have, a predominantly Republican or Democrat makeup, and they'll have several candidates run on the Democratic side if it's a Democrat village, or Republican side if it's a Republican village, and then one candidate on the other party just to kind of represent the opposing party. The purpose of the primary would be to vet out the other candidates so that when you go to the general, it's one candidate from one party versus one candidate of another party. And if we were to do away with that, we may actually cause a situation where those villages that have a predominantly Republican constituency may end up having 2 or 3 Republicans running against one Democrat. And I don't think that was the intent, was to divide their constituencies up like that, to dilute them against a Democratic challenger. So those are other things that we need to consider when considering this legislation. I appreciate the intent of the author to try and save money by doing away with the primary, but if doing away with that will only result in the likelihood of a runoff election, then the savings may not actually materialize. As for me, and in the opening statement of the author with respect to helping new candidates run, I actually found the primary election to be a very informative process as a new candidate. You kind of go through that primary. It gives you that first round of trying to figure out where you stand, and being very data driven. One of the first things my team did, and this is something I would advise for anybody who's running for office, is analyze the data. Right after the primary election, we pulled all the numbers. We saw where we were stronger, where we were weaker, where we needed to direct more of our resources to communicate our message and inform the public of where we stand and what they will get from us if we get elected. And so that data was actually very, very valuable because we were able to figure out, where we weren't reaching out properly. So the primary election, it actually, I think, can help new candidates because it gives them the ability to be able to gauge where their strengths and weaknesses are in a manner that typically an incumbent would have an advantage over because they kind of know the lay of the land already. So I, again, appreciate the intent of the legislation to try and save money, but I don't think that would necessarily be the case. And I do think that the way it would alter the landscape of how the political process unfolds in a manner that the people are used to, I think that alteration may be may be a little extreme. Perhaps, if I could advise, if we wanted to try piecemealing it, we could have certain particular positions not have a primary and see how those elections turn out and kind of ease our way into it. But that's not what we're talking about here today. We're talking about a wholesale transformation and an elimination of the primary process altogether. And I'm not very comfortable with that at this time. Thank you, Mr. Speaker.
Thank you, Senator. Any other senator wish to be heard on the motion, main motion? Is your hand up? No. Vice Speaker, you're recognized.
Thank you, Mr. Speaker. I also have a couple concerns about the bill, primarily because of the testimony from the Guam Election Commission, which, in their opinion, they said would likely require a runoff would likely be necessary, and that the cost of a runoff may offset any savings from a primary. So, for cost savings alone, I guess I'm not that convinced because of their testimony, and although the author has said that according to this court decision a runoff is not necessary, I guess I'm curious why Election Commission is insisting that a runoff is likely necessary. And I guess my other concern is that it's 2017 October. 2018 is right around the corner. We've got a huge elections coming up in 2018, and I am very nervous about changing that, particularly in the gubernatorial race at this stage. I'm not an expert in calculating or predicting the elections, so I really am struggling to see the practical effects of this. I also, I guess I'm also very concerned. I'm a diehard Democrat. However, I don't believe our party or the other party is really set up right now to conduct its own primaries, or even how would we? Does the bill still then allow for the two parties? Because our laws are very clear, they very much set out the two-party system. So would this allow for parties then to really set who could be in the general election? Or does this completely disregard parties altogether and allow anyone to run as a Democrat or a Republican, I guess? And does it require that we declare whether we are Democrat or Republican? I mean, I think those laws are still intact, where we have to, in the general, declare which party, or they're going to place us on sides of the ballot or by party. I'm not sure. Maybe if the author could yield to some of those questions, Mr. Speaker, I would appreciate it.
Thank you very much, Senator. Any other senator wish to be heard? Did you want the sponsor to yield to those issues?
Please. Particularly what happens in the general with the two parties? Do we still have to declare? Does this leave it open for the parties to declare who are running in their slate? Or does it mandate that anyone can run and declare any party, or do they not even have to declare party anymore?
I think the senator, this sponsor was having problems hearing your question. If you would repeat it.
Okay. Can you hear me? I wanted to ask you to please yield if does eliminating the primary allow for the parties in the 2018 election, for the Democrat and Republican parties, to then tell us who is allowed to run as a Democrat and who is allowed to run as a Republican? That would be the first question.
Your question is asking will the parties be able to dictate who runs?
That's correct. That's my understanding of the system prior to this primary system, that the parties determined who ran as Democrat and Republican, and this primary system was put in to eliminate that and to make sure it was the public who determined who would run as, or who would, you know, be on the general ballot as a Democrat and a Republican.
Mr. Speaker, you know, that's a very good question, but we need to also understand that when you register at the Guam Election Commission, you register as a Democrat or Republican or whatever you may be. And unfortunately, the parties have not played a role to actually dictate who are their representative, other than respect who registers as such. So eliminating the primary doesn't stop that, because when they go down and register at the Guam Election Commission, they'll register if they're Democrat, Republican, or Independent. Doesn't stop that at all. As a matter of fact, during the public hearing, both party chairs stated, they actually asked, is it possible to have a closed election? They wanted to have an election that says, if you're a Democrat, you come in with a card that says you're a Democrat, and you get a Democratic ballot. Republicans will do the same. So since that's their statement, then they should run their own convention and not require the people of Guam to pay for their election. The parties should do it themselves.
That is exactly my question, Mr. Speaker. Is the party then allowed to run its own convention, and they are going to tell the people of Guam who is on the Democrat ballot? Is that possible? After we eliminate this type of primary, we leave it up to the parties to determine whatever type of primary, according to their bylaws, they can have. Is that correct? Would you agree with that?
That's
all right.
Correct.
And okay, I guess that's my concern, Mr. Speaker. It's my understanding and that this was changed for very particular reasons, you know, back then because of that system. And I am not sure, particularly I can only speak for the Democrats, if we are prepared to conduct our own election, or, you know, maybe we're going to not, and we're just going to let people get on the general ballot. But I think that the possibility that this leaves open, and I think it's very possible between now and the election that the parties develop a different system that nobody knows about right now, and I guess that's my concern. I would like to know what exactly we are getting ourselves into for the 2018 election, which is right around the corner. I guess I'll leave it at that, Mr. Speaker, and thank you again.
Thank you very much, Senators. Any other senator wish to be heard on the main motion? On the main motion. If not, I guess, Senator Snogestein, you're welcome to... Oh, wait, Senator Espaldon.
I have an amendment.
Thank you, Mr. Speaker. I'm not really sure where I stand on this just yet. I understand the line of questioning and the concerns by the previous speakers. The initial speaker spoke about whether, in fact, indeed, the Supreme Court decision reflected the statements that were made by the author of this bill. And so I was rereading the Supreme Court decision, the U.S. Supreme Court decision, in which there is definitely a case to be made on both sides. And then the previous speaker, the vice speaker, raised concerns basically implying that if there was no primary election, that the parties themselves could choose which candidates will represent the party going forward in their own party elections without going to a primary. And I think what was being implied that there is a danger there that depending on who controls the party at the time will select their own candidates and not really be open to the fact that perhaps other candidates within their own party who are not favorably viewed by the party chair or the controlling committee, right, will then not have that opportunity to proceed forward. However, on the argument by the author of this bill, there is the provision within the law, or at least this proposed measure, that allows candidates to run as independents. And that in itself, I think, has merit, because to date, it's been very hard for anybody to run for a seat. In particular, I'm speaking only from my own experience, to run for a seat for the legislature, for a senatorial slot, unless they belong to a party. I know there was a move several terms ago by one of our former colleagues to try to open that up and allow independent candidates to come in and be able to go straight to the general election without having to go through a primary, which is probably the right way to do it. I mean, there was concern that, well, wait a minute, everybody else has to run a primary election, and yet these candidates have a free pass all the way to the general election. But in theory, that's correct, because the primary is really the selection of the candidates for the various parties. If one doesn't belong to either party, in this case, are neither Republican or Democrat, then they shouldn't have to run a primary, and there shouldn't be so many obstacles in front of them to just try to get to the general election and let their voice be heard, let their stances on the issues be addressed and voted upon by the public. And so this bill, and I like that provision, that because I know there are those out there who probably don't have the support of a party because they've never been really technically party people, but really might be right in the middle of some of the philosophies of both parties. They accept some of the tenets of the Republican Party platform and some of the tenets of the Democratic Party platform. And so they're almost like right in the middle, but they're not really allowed to run either way if they choose to be an independent. And I think that in the end, the independent candidate should have the ability to run without so many obstacles and at least put their name and their platform and their proposals before the people to say, to be able to be chosen or not chosen as a representative in this hall. It does throw into question, though, I mean, this whole proposal, it's a massive reform of the election process on Guam. And I'm disappointed that more people didn't chime in. I mean, we had a few people. And, you know, of course, the chairman of both parties chime in on this particular measure. It would have been nice to have more engagement from the community as a whole, and especially those who might be thinking in terms of running as an independent and not as a party person, to at least state their case. So I'm trying to at least perhaps offer a few words on their behalf, because I've heard many senators of the past, and maybe even some in the present legislature, who actually said that if they had the option to run as an independent, they probably would. But because the process is stacked against these people who want to run as independents, there is no way that they can run and win as an independent. And so that is one of the positive things I think this bill does proffer and put forward. In terms of the money savings, that's a question that will be answered after the fact, right? We can only hypothesize about that at this point, because even then, if there is perhaps a question of whether a candidate, perhaps at the gubernatorial level or at the congressional level, did not receive X amount of votes or a certain percentage of votes, there might be another challenge through the courts to determine whether the supposed winner actually is the winner. Because the arguments of the Supreme Court case that was presented to us really speaks to really the question of whether the count is based upon the votes cast in an election that actually cast a vote for a gubernatorial team, or whether it was 50% or the majority of that, or whether it was the number of ballots cast, whether or not those ballots represent any vote or no vote for a team for the gubernatorial candidates. And there is a difference. And that is, I believe, the reason why the court went that way, that in this case they did not base the percentage of votes cast, the winner, they did not base the winner upon the percentage of votes, of ballots cast, but really on the number of votes who casted a ballot for a gubernatorial slate. And there is a difference. So again, I'm not clear just yet in terms of where I would vote on this, but I need to at least say perhaps some of my own sentiments. And like I said, and to, if anything, at least to bring to light that there are some benefits to this whole proposed legislation, whether or not, because it is a real striking reform of the election process, right? I haven't gone through it to a fine-tooth comb to understand all the little idiosyncrasies that come and perhaps the unintended consequences that may derive from this bill. But thank you, Mr. Speaker.
Thank you very much, Senator. Any other senator wish to be heard? Any other senator wish to be heard on the bill? Senator Nelson? Did I see your hand go up, Senator Esteves? No. Did your hand go up? No. Senator Nelson.
Thank you, Mr. Speaker. You know, I'm a little bit confused about this bill. You know, and I want to thank the author for perhaps thinking outside of the box when it comes to our election process. However, when I first read this bill, I was thinking, every time there's a bill before us, what is the purpose, right? What is it going to impact? What is it going to mean for our community? So one of the main arguments was that we're going to save $447,000 from the primary election if we do not hold it. And on the same token, we have the Guam Election Commission giving testimony saying that may most likely not be the fact. There could be a runoff election and it will be more costly than the money we were trying to save. So I said, okay. And then I thought, okay, what does this personally mean to me? And I was thinking about our election process, and I thought, if something's not broke, then don't fix it. And I find it, you know, going through the process as a first-term senator and as a new candidate, the process was very fair, and you know, it gave us an opportunity after the primary election to really see where we stood, to gauge where we were at, to hear the public's opinions and their concerns in a much deeper scale than if we were just to rev up for one election. And it's true, the good senator from Dededo, he shared, because you know, he gave me a great amount of help during this campaign to understand this process, to understand this political process, because I was very new to it. And I saw that the primary election was a very significant part of our process. And so, you know, I'm conflicted because I respect the author of this bill so much. As an individual and as a colleague, and I really hold him in high regard. But the conflict is for me personally experiencing the election, I didn't see that it was broken. I saw that the process worked, and I saw that the process benefited not only the candidate, but also the community, because we went out there and we went to every forum imaginable under the sun. I thought that I thought it was a gubernatorial race, because I couldn't believe how many forums that we were attending. I mean, as some of my colleagues, you know, we shared, we're like, wow, these are a lot of forums. The people really want to hear what we have to say. And the primary election allowed us to do that. And so I'm still discerning on this bill, But I just wanted to share that for myself. Thank you.
Thank you very much. Senator Castro.
Thank you, Mr. Speaker. First of all, I want to commend the author of the piece for such a bold step towards election reform, but I just have two basic questions if he would yield. So the first question, Mr. Speaker, would be, I guess in theory, having read the piece, it's likely that over 100 candidates could be listed on the only single election, that being the general. That's my first question, and I believe I know the answer, but I would like the author basically to respond for the record.
Do you yield?
Mr. Speaker, you know, I'm not that old, but in all the years I've voted, Senator Will, we've never had more than 50 people. So if you anticipate there's going to be 100 people running for office, I hope that comes. But yes, you could have over 90. You could have an abundance of candidates running in the general election.
Appreciate that, and I guess that lends some credence to the previous speaker from Dededo, Mr. Speaker. Basically, you know, he was asserting that there's some merit in the opportunity for the electorate to make an informed decision, and the previous speaker also alluded to that in the number of forums that are typically provided up until the primary and following the primary, and I was a participant in that. I just would find it as a matter of pragmatic, you know, just common sense that it would be very difficult for the electorate to make an informed decision if you I want it, don't get me wrong, I want as many people to run. But I think there's something to be said for sort of a vetting process. And so to the previous speaker, my minority leader, I do like the fact that the opportunity for folks to run as an independent candidate could be upheld with this piece. But my second question then, Mr. Speaker, to the author would be, based on the bill as it's written, is it possible that perhaps the top 15 vote getters out of 100 or 30 or 90 or 200, those would be the folks, based on the way the bill is written, that would be reflective of the political will of an entire community? So it's likely, I guess my question is it likely that if a certain candidate garnered 5,000 out of 30,000 votes cast, that you would see that as being befitting of accurate representation of the political will of the people?
Yes, I actually, you know, Senator, is that yes, the answer would be yes, if that's what is to happen.
Thank you, Mr. Speaker. That's it.
Any other senator wish to be heard? Any other senator wish to be heard? If not, Senator, you're welcome to close.
Mr. Speaker, before I close, I'd like to actually introduce amendments, because it was, as I spoke with the legal, they found that there were other titles and chapters that require the word primary to be striked out. That has been all provided to my colleagues. If you want, I would have to read it out. No?
How extensive is it? Maybe we might need a copy.
I have 5, but they've all been passed out. It only strikes out the word primary on each of the titles.
Why don't you just tell us what page on the bill, your bill, and maybe we can just...
Well, on the bill, it'll actually follow at the end of the bill. It'll like identifying removing reference to primary and prohibition against salary increase following defeat of an incumbent. And this is on Title 4, Chapter 6, as amended to read that towards the end of that paragraph, the word primary election will be striked out in that primary on that chapter. And then on the other amendment, it'll identify Title 4, Chapter 8, 81-38.1C, the transition, classification of office, transition, issue, and subsequent election and appointments. In that paragraph where they have the word primary, it'll be striked out. I'll just continue reading that for you. On the other amendment, Title 17, Chapter 3, 3102.3 is amended to read that where it has the word primary election will be striked out, and that's referring to the composition and forms of office for board members. The next one would be Title 21, Chapter 61, 61542H2. This refers to the primary in regulations of political signs, where we strike out the word primary election. And then on Title 21, Chapter 61, 61542E, regulation of political signs, refers to the period of erecting the signs for the primary.
So he's adding new sections to the bill. That's what he's doing. Just add new sections to the bill.
Actually, let's take a short recess because it's not just a simple strike of a word. It actually, we're adding new sections to the bill. So just a short recess, and we'll get the copies for everybody so they understand. Senator Augustine.
Mr.
Let's
Speaker.
do these individually, just so that
Yes.
everybody has a chance.
Yes, sir. Mr. Speaker, the amendment is to add a new section to the bill to read, removing reference to primary and classification of offices, transition, initial, and subsequent election and appointments. Which is the Title 4, Chapter 8, 8138.1C, Guam Code annotated.
All right.
Well, I'll just continue reading.
And, yeah, well, any objection to this amendment? Any objection to the amendment? Your next one.
Mr. Speaker, to add a new section to the bill to read, removing reference to primary and regulations of political signs. Section 61542E of Chapter 61, Title 21, Guam Code annotated.
Any objection to this amendment?
Mr. Speaker, to add a new section to the bill to read, removing reference to primary and regulations of political, Section 61542H2 of Chapter 61, Title 21, Guam Code annotated.
On this amendment, any objection?
Mr. Speaker, to add a new section to the bill to read, removing reference to primary and composition and forms of office for board members. Section 3102.3, parenthesis B, parenthesis 1 of Chapter 3, Title 17, Guam Code annotated.
On this amendment, any objection?
Mr. Speaker, to add a new section to the bill, removing reference to primary and prohibition against salary increase following defeat of an incumbent. Section 6230 of Chapter 6, Title 4, Guam Code annotated.
Any objection to this amendment? Thank you. On the motion to send the bill down, do you wish to close or just send the bill down? Senator Espaldon.
Mr. Speaker, I know this is an unusual request, but notwithstanding the House rules, because I've been asked by several of our colleagues to perhaps expound upon something that I had said earlier, if I'd be able to perhaps speak a little bit more on this bill.
You're recognized.
Thank you, Mr. Speaker. Mr. Speaker, in my presentation earlier, when I was addressing the issue of whether or not, or the potential that there may be further challenges, right, and whether the reading and the statements of the author of this bill was correct, excuse me, of the decision by the Supreme Court was correct, and that there will always be a majority. And I needed to perhaps expound upon the thought that that may not be the case. Because as I had said earlier, in the case that was presented before the Supreme Court, the court ruled on a very narrow issue. And that issue that was brought before it was whether a majority is reached for someone to win at the gubernatorial level in this case, in the court case before the Supreme Court, was it reached based on one argument in the case said that Governor Gutierrez did not get a majority of the ballots cast. The argument against that was that they had the majority of the ballots that contained a vote for the gubernatorial election. And the Supreme Court basically said that Governor Gutierrez did win that election And they based it upon that he got a majority of the votes that were cast that identified a preference for a gubernatorial team, not the total number of votes cast. Because in that particular election, I believe there was like 1,300 votes that stated no preference for either team, whether it was for the Gutierrez team or the ADA team. And the court basically said, no, we can't, that's not the case. It's going to be the majority of the votes cast who showed a preference for one or the other teams. And that's how they arrived that Governor Gutierrez did win that election, because if you take it by that number, then Governor Gutierrez won with 51%, or over 50% of the votes cast that showed a preference for which team should be in Adelup. The part that I'd like to add and expound upon now is that there is that possibility, much like was brought up by one of our colleagues, who previous speakers, is that if there was no primary and narrowing down of the field, then you could potentially have a 3- or 4-way race in which nobody would get a majority of the number of votes cast that showed a preference. I mean, you take away all the ballots that didn't cast a vote for any team, any of the 3 or 4 gubernatorial teams that may be in this race, right? Now you come up with that 100% figure of those who did cast a vote. And technically, there is the highest of possibilities, right, that none of the 3 or 4 teams, or maybe even more, would ever get a majority of the votes cast for governor. And there would then necessarily have to be a runoff, because nobody got a majority of the votes cast that showed a preference for who the governor should be. If we just look at numbers, if it was split if there are 4 teams running and everybody got this, basically a little bit of the same amount of votes, you might get a team that got 30%, you might have another team that got 25%, you got another team that maybe got 15%, etc. But nobody will have had a majority of votes cast who showed a preference for which team should go to Adelup or become governor, and that would be the runoff. And that would be the danger of going forward without a primary election, to narrow that field down to that point. That's the problem with this bill. Thank you, Mr. Speaker.
Thank you very much, Senator Espaldon. Senator Snogestein.
Mr. Speaker, the bill I introduced is to basically not have the people of Guam pay for the primary. If the parties want to have a primary and they do their convention, then they present it to the Election Commission that these are their candidates, then so be it. If you look at the bill, it's mainly focused towards that the people of Guam stop paying for the political party's decision. They should make their decision and then move forward from there. Thank you, Mr. Speaker.
On the motion to send the bill to the voting file, any objection? Oh. Did you wish to be? Go ahead.
I just wanted to know if the author considered is there any savings in eliminating a primary for one race but not the others? Like, for example, eliminating a primary in the legislative race but not the gubernatorial race. Would there be any financial savings?
No, there won't be. If you eliminate the primary, that was spoken earlier by Senator Torres, that there's about $400,000, that's what you eliminate. But at the same token, if it's ruled by the Election Commission that there wasn't a majority voted, then that will determine what the cost would be.
All right, on the motion to send the bill down to the voting file. Thank you. Next on the agenda, Bill 92, Senator Camacho Torres.
Mr. Speaker, I respectfully pass on Bill 92.
Thank you. Following on the agenda, Bill 161. Did we make copies of the revised bill? Please. Oh, okay. We'll just take a short recess. Next on the agenda is Bill 161. Senator Snodgrass Sr. recognized.
Thank you, Mr. Speaker. Mr. Speaker, I move to place Bill 161-34 on the third reading file and would like to discuss it.
Hearing no objection.
Mr. Speaker, before I even discuss further, I'd like to identify that I have amendments to the bill, and it has been passed out to include the replacement of Exhibit A with a new Exhibit A. And as everybody has the bill, the first amendment is to delete Section 1 of the bill and amend Section 2 of the bill to read: grant administrative jurisdiction of lot number 5173.
Point of order, Mr. Speaker.
Yes,
if
sir.
we could just bifurcate those two issues. The first issue is to whether or not to delete Section 1.
Okay.
Not delete,
The intent.
to delete Section
Right.
1.
Right. And so I think a vote is necessary for that, and then we can move on to
All right,
Section 2.
Any objection to deleting Section 1? Hearing no objection. On Section 2, go ahead.
Okay, on Section 2 of the bill to read, grant administrative jurisdiction of lot number 5173 new -2 -R1. Change that and then delete the portion, line left, let me go to this one real quick. Basically, you're on line 8 on page 2, or correction, line 12. You're striking out the from R2 all the way across and replacing that with from line 11 to R1 at the end, and then adding excluding 0.17 acres plus or minus, which is bounded on the west on Chalan San Antonio and on the south by GTA facility as depicted on the Department of Land Management map, which is now the new Exhibit A, check number 265 FY89.
Does everybody follow that?
Thank you, Mr. Speaker. Mr. Speaker, I've passed out this aerial photo that's colored, and this provides a graphic representation of the amendment that's being made. So if everybody takes out their aerial graphic, you'll see on the upper right hand corner, it shows the arrow with the N on top. So that depicts then north, all right? And so with the change that is the amendment that's being made to the bill, what is going to be, I'll just orient everyone. On the top part of the graphic is LBJ Elementary School. The bottom, those series of buildings, that's the Tamuning Elementary School. And then the big open area that's shown here, that's the baseball field that everybody's familiar with. And you'll see there a small blue building. That's that store right along Chalan San Antonio, the blue store. And so with the changes that were made, what's going to be turned over or from the Chamorro Land Trust land inventory and placed under the jurisdiction of the Tamuning mayor is that open area where the baseball field is. That's all we're doing. However, the language states excluding 0.17 acres plus or minus, which is bounded on the west by Chalan San Antonio. And what we're doing is we're actually carving out that 0.17 acres where the blue store is located. because in the testimony, the executive director for Chamorro Land Trust Commission the Chamorro Land Trust wants to keep that 0.17 acres, almost a quarter of an acre, because that's a commercial piece. And they want to be able to rent that out, lease it out, and make that be a revenue generator for the Chamorro Land Trust. So then essentially, so then the entrance into this baseball field and where the basketball court is going to be that basically that dog leg that's right south of the GTA facility and just north of the school itself. And so that's how the mayor accesses the baseball field. So this is a graphic presentation, representation of the amendment that is being made, that is being proffered by the sponsor. This has been cross-checked, of course, with land management, and we've had the subject matter experts on the committee take a look at this and agree that with this amendment, that's basically what we really had intended from the very beginning to accomplish.
The color graphic and the map, unless I'm reading it incorrectly, differ on what's left out in that 1.7 acres.
That's correct. This map that is being used as the you'll see on this particular map on the upper left-hand corner, it is identified by DLM check number 265-FY89. So that represents that this was a survey that was done in 1989, and unfortunately in that survey it shows everything from that lot 5173-new-2-R1 that includes where that 0.17 acres is. So so with the bill, we're saying this is correct, however it does not include the 1.7 acres that's right alongside the Chalan San Antonio.
So the line that's, I can see the GTA box, but the small area next to it, should that line that's on San Antonio be back on the backside?
Which one are you looking at? Are you looking at the color graphic or the map?
Map.
So the map then, well, it shows here, actually, I guess the official, I guess that particular road is a routed road, and that's otherwise known as Route 14. Otherwise, many of us know it as Chalan San Antonio. So the way the amendment reads is that we are giving.
So the way that we should read this is everything within those dark lines, except for the little square where the little blue box is.
Correct.
That's 1.17 acres.
Correct. And
okay.
So it may be helpful to. It may be helpful that part of the attachment then is the official map and the graphic, which then shows a pictorial translation of what it is that we have here.
Okay. All right.
Okay.
Thank you. Do I understand that? Oh, you have a question, Senator Nelson? Please.
Thank you, Mr. Speaker. I just want to clarify the exclusion of the 0.17 acres on the amendment, which is bound on the west on Chala, San Antonio. It's still a part of the original lot number 5173 new -2-R1, if they would yield. Yes, okay. And so we want to exclude 0.17 acres from this original lot, which we are giving administrative jurisdiction to Tumaning, to Mount Harmon Mayor. Is that correct, Mr.? Okay, thank you, Mr. Speaker. So I just want to bring up a concern. I don't know how to say it in any other way, but is this 0.17 acres has not been properly surveyed and cut out. Is that correct? It's still a part of the original lot? Okay, thank you. And so I just want to caution us as colleagues. I've never known this cutout of a map that has not been surveyed and stamped by Department of Land Management as proper documentation to attach as a change in excluding 0.17 acres. And I want to say that it's nothing new that my grandfather, I learned this from him. He's very particular when it comes to accountability and land and in the way the surveys are done. And it's been on the news throughout the years, and my concern is here we are doing this unorthodox, unconventional, improper practice of interpreting that 1.17 acres, because we see it in a picture, is proper documentation to attach to a bill that we are going to authorize should it pass to become law. So I hope that we get a proper survey. Otherwise, I cannot agree to saying that this is justification for what we are about to do here. Thank you, Mr. Speaker.
Thank you, Senator. Senator Nicholas.
Thank you, Mr. Speaker. I appreciate the diligence of the retiring speaker to point out the concern. I just wanted to kind of follow up with that then, because I'm referencing the bill and I'm looking at Exhibit E. And Exhibit E is identifying a specific lot. And Exhibit E also looks like it's a copy of a Department of Land Management map. And I'm just wondering, would this documentation be sufficient to properly identify what it is that the bill is intending to do? If I may inquire of the author.
I think the oversight chair.
No, so the document that's being referred to by the senator, no, that would not be a sufficient document to use really as an attachment, because on that particular document, on the upper left-hand corner where it says special notes, it says that this is for information only. On the bottom right-hand corner, it says it is a proposed lot, as opposed to this document, which shows the official approved map of those lots.
Well, that being said, Mr. Speaker, I'm just concerned that because we are not specifying the legal description of the area, nor, as the retiring speaker so effectively clarified, are we specifying any subdivision of those areas. I think that it may be premature to entertain the measure. And with deference to the chairman of the agency of oversight of this measure, I would like to, unless he objects, make a motion to refer the bill back to committee until such time that the proper documentation is included to effectively identify the area on a legal basis, Mr. Speaker.
There's been a motion to send the bill back to committee, and Vice Speaker, did you wish to speak on that motion?
Thank you, Mr. Speaker. I agree it's very confusing, but I'm hoping maybe we can just work through it. But it's confusing also primarily because I want to rely on the Department of Land Management's testimony. I'm figuring they should be the expert, and they went to great extents to describe the different lot numbers and how we should describe the transfer. So I guess I want to ask the committee chair if he would yield. Attached to the bill, shoot. They're not all labeled consistently either, so let's just see. There's Exhibit A, so not that one, not Exhibit B, and not the next page. But the next page, maybe it should be labeled Exhibit D, because the page after that is Exhibit E. So let's say it's Exhibit D. Is this map the same as the map that was just handed out this morning? Is that identical to the map that was handed out this morning but just blown up? It looks like it. Because instead of the handwriting on, the paper that was passed out this morning that says from DLM check number, if this is the same, it's just very hard to read.
So I would clarify then. I think the map that you're referring to, it is identified on the upper right-hand corner as Exhibit D, Bill 161-34. This was a map that was provided by the Department of Land Management Director. The other one that was being made reference to, which has the identification DLM check number 265-FY89, is just a blown up copy of this.
I think that helps to clarify, Mr. Speaker, that this map, that if we reference this exhibit, and if we could just clarify then what Exhibit E is, proposed lot scheme. Okay, because the Director of Land Management also referred to the proposed lot scheme, but the references to proposed lot scheme are being deleted, or the amendment is to delete those references and use the map instead.
So you want me to
Right.
yield?
Oh,
So
yeah.
this Exhibit E, this is a sketch, okay? And again, this was provided by Department of Land Management for information only, and a graphical representation of what the bill was proposing to do. What the bill was proposing to do is I would ask everyone to look at the aerial photo. But what had happened over the years was LBJ Elementary initially started with just that piece on the north side, right? And then somehow the additional buildings that's going north and south, that actually encroached into land trust, Chamorro Land Trust property. How that happened, I don't know, but it happened. And so when you read the bill and you try to follow it, it was going to take that portion of the land, which is about 1.2 acres, and put that under the jurisdiction of the Tamuning mayor. And you really don't want, it doesn't make any sense to do that. So part of the amendment that's being made is saying, no, we're not going to take that 1 acre lot that's currently being occupied by those LBJ buildings. Just disregard that. And all we're give over to the Tamuning mayor is the big baseball field, less that 1.7 acre commercial lot. Maybe if we take a recess and we can huddle around so that way we can actually point.
Actually, I think the motion to send it back to committee is probably the best. The bill will be sent back to committee.
Do we want to send it back with all amendments intact then?
Well, yes, but bring back to the floor whatever should be brought back. The bill only references Appendix A, and we have now Exhibit E, and let's just clean this up. Senator Esteves?
Mr. Speaker, just a point of information. I believe when the issue came up of the 0.17 acres, that was proposed as an amendment to the bill. Were we to dispose of the amendment first before a motion to send the entire bill back to committee?
No, let's send the entire bill back and have one clean bill that comes to the floor when we meet next month.
I'm just saying the bill as it is right now on the floor is not at debate right now. The only thing that's being debated is the amendment.
I understand, but the motion is to send the entire bill back, and I'm sending the entire bill back and they will clean it up and then send it back.
And that we're able to make that motion when the question is still regarding the motion on the amendment?
Yes.
I would make a motion to amend that motion to send it back to committee, Mr. Speaker, and ask that it just be, that we reconsider this in the afternoon today.
This is the only thing this afternoon, so everybody be back at 2. Fine. Recess till 2.